Hi Sylvia, thank you for joining us. We're here to talk about the Class Action Fairness Act of 2005. The Class Action Fairness Act, or CAFA, allows removal when a putative class action is filed in state court, when there is minimal diversity satisfied, that is, one defendant is from one state and a member of the putative class is from a separate state, and then when the amount in controversy requirement is satisfied, that is, there is more than $5 million at stake, exclusive of costs and interests. Now, Sylvia, I know that you and Joe Lang wrote a short article on removal dealing with CAFA, and that article is available on the firm website. What are some things that you take away from the research that you did?
Matt, the decisions in 2011 make it clear that the test for the amount in controversy required to establish federal jurisdiction is not always easy to satisfy, and it's critical that the defendant seeking to remove a case to federal court come forward with record evidence before the district court of how a recovery by the plaintiff, assuming the plaintiff's theory of the case and assuming the plaintiff prevails under that theory of the case, how the recovery could exceed the amount in controversy requirement. Obviously, you don't want to concede that you're going to be liable for that amount, and you have to have appropriate caveats, but all you have to prove to the satisfaction of the district court is that under the plaintiff's theory of the case, it's plausible, it's not impossible, that the recovery could exceed $5 million. And there may be types of damages that clearly help you get to that level. One of the cases, for example, involved injunctive relief, and the Court of Appeals held that the amount in controversy was satisfied because the cost of complying with the injunctive relief was more than, just in the words of the court, reprinting a form, but in fact would involve other compliance costs as well. But this is a jurisdictional requirement, and it is one that has to be established with record evidence at the time of the removal and opposition to remand.
Now, Sylvia, is there a frequent issue that arises with respect to the amount in controversy?
In 2011, we saw a number of cases in which the plaintiff attempted to avoid removal to federal court by disclaiming any intent to seek more than $5 million in a recovery. If that happens, it's very important to examine the precise language of the concession to make sure that it would be binding in the future to preclude later efforts to recover greater damages once the danger of removal to federal court has gone away. So it's important to assure on the record as best you can that there's going to be no future effort to obtain a greater recovery. Or you may want to not embrace the concession at all and assert that it's simply unavailing because the plaintiff as a class representative has a fiduciary duty to maximize recovery and cannot avoid removal and thereby forum shop by the simple tactic of not pursuing certain claims or disclaiming certain types of damages such as punitive damages.
As you know, Sylvia, CAFA only applies to class actions filed in state court. One of the issues that has come out in the cases in 2011 is whether a parens patriae action filed by a state attorney general in state court constitutes a class action within the meaning of CAFA. Did you see any discussion of that in the 2011 case law?
Yes, 3 courts of appeal reached that issue in 2011, and all of them concluded that those types of cases were not class actions and could be brought without danger of removal to federal court. And I believe in light of that unanimity of decision that we are going to see more of these kinds of cases being brought by state attorney generals, perhaps in conjunction with private outside lawyers representing the state in such suits. The question of whether such suits are class actions nonetheless ought to be raised in those circuits that haven't resolved the issue. There was a dissent in one of the cases relying on the so-called duck test, that if it walks like a duck and it quacks like a duck, it probably is a duck. And the dissenting judge was of the view that a parens patriae case seeking exact same relief that would be sought in a class action walked and quacked like a duck and was a duck. So that's obviously an issue that should be raised in other circuits.
Any last lessons learned from these decisions?
Remember that the Court of Appeals may resolve the merits issue on the briefing for leave to appeal. That happened several times in 2011. And there's a tension, accordingly, in being sure that you have enough in your petition about the merits of the issue so that the Court of Appeals will get it right if that's what the court elects to do without further briefing, and yet nonetheless making sure that your petition complies with setting forth and establishing the factors for gaining leave to appeal in the first place.